Thank you, Mr. Speaker. And it's always an honor to rise in this place and to speak on behalf of the good people of Okanagan Lake West, South Kelowna. I will inform you, Mr. Speaker, that I also have the honor of sharing my time with the honourable member from Richmond Marpole. Now, this past week, Canadians, particularly British Columbians, received deeply troubling news. A new survey from the Business Council of British Columbia found that nearly 3/4 of businesses plan to reduce investment and 1/3 plan to reduce hiring because of the growing uncertainty around property rights and land title in this country. Now, this uncertainty is not theoretical, Mr. Speaker. It is very real. It affects homeowners, employers, municipalities, and investors who believe that in Canada, fee simple ownership meant certainty. Now, since the Cowichan ruling, Mr. Chair, I have to say I've received calls, and I was a bit shocked because Westbank First Nation is in the heart of Okanagan Lake West, South Kelowna, and they sit side by side with the city of West Kelowna. And I had people that live in Westbank First Nation ask questions about their property and whether or not their investments were safe. And it's not surprising, Mr. Chair, because today's debate is really around a simple question. Because people in my riding are asking us, will this House of Commons stand up for Canadians who followed the rules and invested their life savings, or will you allow uncertainty and inaction to undermine private property rights in Canada? Business leaders are clear about what is driving this concern: increased costs, delay, complexity, and unpredictability caused by this court ruling, policy reversals, and an ever-changing legal landscape. As a result, investment, Mr. Speaker, is being shelved. Jobs are at risk, and confidence is eroding. What we already know is alarming. Fee simple titles held in the City of Richmond, by the federal government and the Vancouver Port Authority are now potentially invalid or effective due to this ruling. What we do not know yet is the full impact on private landowners, people who worked hard, followed every rule, paid their taxes, and put their entire life savings into their homes and businesses. They are worried, and rightly so. Now, when these concerns are raised, members opposite respond by accusing critics of fear-mongering or spreading misinformation. This is what Liberals tend to do when they do not have a substantive answer to serious questions. Because these are serious questions. To those making those accusations, I would offer this. It was this Liberal government that adopted Litigation Directive 14. That directive restricted the arguments Crown lawyers could make in court to defend fee simple property rights. That is not rhetoric. That is documented policy. Litigation Directive 14 is not fear-mongering. It's a fact. It's an inconvenient fact for the Prime Minister and his government, one that they have refused to explain why this is still on the books and instructing lawyers within their employ. The Prime Minister has been asked repeatedly why his government has continued with this directive, and he has continued to avoid giving a clear answer. Why did this Liberal Prime Minister refuse to stand up for property rights, Mr. Speaker, when it mattered? That remains unanswered. But what we do know now is after the damage has been done, the Prime Minister says he disagrees with this court decision. He now says that private property rights are fundamental and that his government will defend them. Well, I'm happy to say, Mr. Speaker, the Prime Minister will have that opportunity with this motion. This Opposition Day motion gives the Prime Minister a chance to match his words with action, something that is increasingly difficult for this Prime Minister. Will he vote to defend private property rights, or will he vote against them once again? This motion proposes practical, substantive, and achievable steps to help restore certainty and confidence. First, it calls on the government to put private property first in the Cowichan case by clearly arguing that fee simple ownership has priority. I've heard the term viable answers or viable arguments, Mr. Chair. That does not necessarily mean they are making every argument. Now, second, it calls specifically for Litigation Directive 14 to be replaced with a clear requirement that the federal government aggressively defend property rights in all litigation. Third, it requires that no agreement can be concluded without explicit protection of fee simple property rights in all future negotiations with First Nations, so everyone understands and has some certainty, something that has been failed to have been done under this government and its predecessor. Fourth, it demands a concrete plan from this Prime Minister within 30 days, complete with timelines to protect Canadians affected by the Cowichan decision and the Musqueam Agreement. Finally, it establishes a special parliamentary committee to examine every legal, constitutional, and political tool available to protect private property rights in Canada. Now, Mr. Speaker, these are not radical proposals. They are not ideological. They are responsible. They only become controversial if one does not believe that private property rights are fundamental to our system, both in terms of our system of capitalism in this country and in our Westminster system. We've always honored these things. And the lack of certainty that we see today is causing real harm. It is freezing investment, encouraging litigation, and forcing Canadians into a legal limbo with no clear path forward. Now, this is despite all the Prime Minister and his Liberal members of Parliament, as I've heard described in the Toronto Star, his deputies. They are all describing that everything that Conservatives are saying is not true. So, Mr. Chair, it should not be this way. Behind closed doors, negotiations are occurring with public tax dollars on the line, while affected Canadians are left without consultation, clarity, or protection. Lawyers disagree. Experts disagree. Lawsuits are multiplying, and government is failing to protect the interests of some of the very people it claims to serve. British Columbia already faces enough challenges. One can look at softwood lumber, American tariffs, and a NDP provincial government that appears to have no idea of what it's doing. We do not need to add property rights chaos to that list. Well, I guess it already is, but we got to make sure that we pull that off the list. And this motion, Mr. Chair, Mr. Speaker, is a way to do that. Now, this Prime Minister often says that we should focus on what we can control. Well, today, this motion, this House can control something. We can restore certainty. We can defend property rights. We can stand up for Canadians who, by every account, have done everything right. That's why I will be voting in favor of this motion. The Prime Minister himself has said private property rights are fundamental. Today, we will see if his words mean anything. So I urge all honourable members to support this motion and send a clear message. In Canada, private property rights matter. We hear the concerns raised by British Columbians. We know we have the means of which to address them, and that we are dedicated in service to ensuring that their rights, their concerns are addressed, not in some far-off land, Mr. Speaker, in some yet-to-be-determined time, but here, now, this Parliament, this country. Thank you.
And comments.